What is a conservatorship? When an elderly individual loses the capacity to rationally manage their finances, a judge can appoint a conservator to step in and take control of their assets. The extent of the conservator's authority will depend on how mentally incapacitated the elderly individual is. The court can appoint a conservator to handle a single transaction, such as selling a family home, a limited set of activities, such as paying bills, or the court can issue a broad mandate to manage all of the individual's assets. In a conservatorship proceeding, the incapacitated adult is referred to as a protected person. When is an elderly individual considered to be incapacitated? According to Arizona law, specifically in ARS Title 14, Section 5101, an adult is considered to be incapacitated when they lack the capacity or sufficient understanding to make or communicate responsible or rational decisions concerning their person or well-being. In most cases, incapacity is caused by one of the following impairments: chronic drug use, chronic intoxication, disability, mental deficiency, mental disorder, mental illness, or physical illness. It's important to note that an elderly individual's poor financial choices don't necessarily qualify them for conservatorship. To be considered incapacitated, the elderly individual will need to have one or more of the impairments listed. A recent history of financial mismanagement or susceptibility to fraud may be an indicator of mental deficiency, but on its own, it's not enough to warrant a conservatorship. The person must have assets, and you must show that if protection is not provided, the person's assets will be wasted or dissipated. What can a conservator do? A conservator has the same fiduciary duties as a trustee in Arizona. In both cases, the individual managing the assets is required to exercise the same prudent administration that a regular investor would when handling their own assets. Conservators also have a duty of care to the protected person, and they're required to place the needs of the protected person before their own. In a conservatorship, the conservator could have any or all of the following rights and responsibilities: acquiring an undivided interest in an estate asset, acquiring or disposing of an estate asset, including land in another state, allocating items of expense or income to the protected person's estate, borrowing funds and advancing money to be repaid by the protected person's assets, collecting, holding, and retaining assets of the estate, including land in another state, until in the conservator's judgment, disposition of the assets should be made. Contesting, settling, or paying claims by or against the protected person by arbitration, compromise, or otherwise. Defending or prosecuting actions, proceedings, or claims. Demolishing improvements to real estate and property. Depositing estate funds in a state or federally insured financial institution. Distributing income and or principal to the protected person and other beneficiaries. Employing professionals, including agents, financial advisors, auditors, and attorneys, to assist or advise the conservator in the performance of their administrative duties. Entering into a lease as lessor or lessee, with or without an option to purchase or renew for a term within or extending beyond the term of the conservatorship. Erecting new or raising existing property walls or buildings, executing and delivering instruments, holding securities in a nominee's name or in other form without disclosing the conservatorship, insuring the conservator against liability, insuring the protected person's assets against damage or loss, investing and reinvesting assets, ordering repairs or alterations to buildings or other structures, participating or continuing in the operation of any business or other enterprise, partitioning by giving or receiving considerations and dedicating easements to public use without consideration, paying all necessary taxes and fees, including compensating the conservator incurred in the care, collection, and administration and protection of the protected person's assets, paying assessments for securities, receiving additions to the estate, selling or exercising stock conversion or subscription rights, and consenting to the liquidation, dissolution, merger, consolidation, or reorganization of a corporation or other business enterprise, subdividing, developing, or dedicating land to public use, taking an option for the acquisition of an asset, or granting an option involving the disposition of the protected person's assets, and finally, voting a security in person or by general or limited proxy. When does conservatorship end? A court-appointed conservatorship is designed to last as long as the protected person needs it. If the protected person is temporarily incapacitated, like in a medically induced coma or recovering from an illness, then the conservatorship will end when the protected person regains their decision-making capabilities. If the incapacity is permanent or a worsening condition like dementia or Alzheimer's, the conservatorship will typically end only when the court terminates the appointment. Alternatives to conservatorship. Considering how conservatorship strips someone of their decision-making abilities, conservatorship should be the final option. It's always better for the elderly individual to willingly authorize someone to take control of their finances. As long as the elderly individual has a sound mind, they can authorize a family member or friend to handle their finances with a durable power of attorney. The power of attorney can offer broad access to their assets, or it can limit the agent's authority to certain assets and activities. A power of attorney can bestow immediate authority, or it can withhold the authority until the agent becomes mentally incapacitated. What is the difference between conservatorship and guardianship? Where a conservator's responsibilities are limited to handling a protected person's finances, a court-appointed guardian is given authority over the protected person's health care, living situation, etc. Guardianships can be limited to certain activities, but most of the time guardians are given a fairly broad mandate to care for the protected person. These protected people are also called wards in guardianship proceedings. Generally speaking, a guardian has the same rights and powers that a parent has over their biological child. If you have questions about whether you need to seek guardianship or conservatorship for a loved one, reach out to our attorneys at Jackson White at 480-618-0351 to discuss your case today.